hello, hello. Yes, thank you, and I thank all of you for coming to this Constitutional Law Center event focusing on debates over whether former President Trump can be, or as Will would put it, is already disqualified from serving as president a second time because of a previously obscure portion of the 14th Amendment, Section 3, the words of which are up here, so you can follow along and see whether any of us are departing from it. So I'm not going to give a long introduction here, but we're going to begin with Professor Will Baude from the University of Chicago, who has really set off the current round of debate on this topic with an article that he and our old friend Michael Paulsen have written on the sweeping, he can give the exact title, but the sweeping nature of Section 3's disqualification provision, which has been published in various shortened forms and blogs and so forth, and is complete. And one of the reasons I think why it has captured so much attention is that Will and Michael Paulsen are card-carrying originalists and members of the Federalist Society. So, this is not just one more left of center, attempt to bring down Mr. Trump. This is people from, within the conservative and originalist fold who are trying to bring down Mr. Trump. And he's going to speak first. Most of you know me. I'm Michael McConnell. I teach here at Stanford. I think I may be the only person in the country who actually has taught Section 3 because I teach a course here on the Reconstruction Amendments and always devote a portion of that to Section 3, even before Will and Michael taught or wrote their draft. And I'm going to be responding. He and I are going to share methodological assumptions. That is, we're going to be relying on text and history. And then our friend Eric Segall is with us tonight from Georgia State, the law school at Georgia State University. He is one of the country's leading critics, I think it's fair to say, most intelligent and insightful critics of originalist methodology in constitutional interpretation. And so he is going to disagree with both of us about how it ought to be done, but also disagree with Will's conclusions on the subject. So that'll give you a panoply of possible approaches to Section 3. Two housekeeping matters. At the end of our 1.5-hour session, we're doing this slightly longer than the Con Law Center events usually are. At the end of the 1.5-hour session, there will be a reception outside to which everyone is invited to come, and you'll be able to talk to the speakers and so forth. Second, for at least half an hour and maybe more if we exercise any kind of self-restraint, which probably no more than half an hour. There'll be time for questions from you, the audience. You'll see a microphone there. Please do stand, if you have a question, come and queue up behind the microphone, and please do speak clearly into the microphone because this will be, I don't know, what do you say, published, broadcast, whatever, a few days from now on our website to those who don't have the good fortune of being here in person. So with that, I'm going to turn it over to my old friend and former law clerk, Will Baude.
Thank you, Michael. So Section 3, as Michael said, is a previously obscure but once very important part of the 14th Amendment to the Constitution, adopted by Congress, ratified by the states in the wake of the Civil War. And it says that no person shall be a senator or representative in Congress, or an elector of president and vice president, or hold any office, civil or military, under the United States or under any state, who having previously taken an oath as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each House, remove such disability. In other words, people who have previously held constitutional office have taken an oath, and subsequently engaged in insurrection or rebellion, or given aid or comfort to the enemies of something, can no longer hold office in the future. But Congress retains the power to grant amnesty, effectively, by a 2/3 vote, if it wishes to. I have written, for people who want the full, the full program notes, I have written a 126-page article about the sweep and force of Section 3, which is just a description of how much sweep it has and how much force it has. The title is not committing to whether it has a lot of sweep or a lot of force, but it does. But I have 10 minutes and 6 points to make, so I think that gives me about a minute and a half for each point, on average. The first point is that Section 3 lives. It remains an enforceable part of the Constitution that applies now. That might seem in some sense obvious. It's there in the Constitution. The Constitution is part of our fundamental law. But it has not always been obvious to everybody, so it's worth just laying the groundwork. One point, Section 3 applies to insurrections and rebellions beyond the Civil War. At the time it was adopted, obviously, the central focus, the reason it was adopted, was the Civil War, which is euphemistically called insurrection or rebellion. But it's written in general prospective terms. And indeed, there were other versions of Section 3, or of similar kinds of provisions, that were not, that applied only to those who participated in the late insurrection or the late rebellion and had a sunset clause by 1870 or 1876. They were heavily criticized on the grounds that the Constitution shouldn't contain kind of good for this moment only provisions. That was too political. It should contain general statements of principle. And so the Constitution contains a general statement of principle, motivated, obviously, by the practical problem that immediately after the Civil War, the South was about to send back the Confederate Army to Congress, and people did not think that was a good way to run the Reconstruction Congress. But it applies more broadly. And while Congress has this power, by a vote of 2/3 of each House, to remove the disability, and it has exercised it for all for everybody in the Civil War, in 1872 and then in 1898, Congress passed two pieces of amnesty legislation that together covered the waterfront of everybody who committed insurrection or rebellion during the Civil War. That legislation doesn't, and indeed probably can't, sort of sunset Section 3 going forward. There is not like a general prospective amnesty on the books. Some courts that have heard litigation about Section 3 in the past couple of years have disagreed, which is the reason I mention it. I think it's pretty obvious, but happy to talk about it more if anybody wants to disagree. Okay, so this provision is on the books. It's an enforceable rule of our constitutional law, which raises the obvious questions of what does it mean and how does it work? The more important questions. Brings us to point number 2. Point number 2, Section 3 is self-executing. What it states is a disqualification from office. Indeed, if we had the whole Constitution up there, you can see that there's a parallel in the language of Section 3. No person shall be a senator or a representative who, and the other qualifications contained in the Constitution that we take for granted. No person shall be a senator who has not been a citizen for a certain number of years. No person shall be president who's not a natural-born citizen, and so on. The Constitution contains a list of qualifications for federal offices that are all phrased like this. They're just rules about who can hold office. And Section 3 adds one more rule to the list in sort of consciously parallel fashion. What that means is that it doesn't require implementing legislation to take effect. People have sometimes described Section 3 in recent years as something that, like, maybe Congress should activate. Like, maybe Congress should cause Section 3 to come back to life. But just like the other qualifications to office, it's already there. If Barack Obama or George W. Bush were to try to run for a third term as president, they would not be allowed to, because another provision of the Constitution says that they can't be president, having been president for 2 terms before. Congress doesn't need to do anything about that. That's just a rule. So, too, Section 3 is just a rule. Similarly, it's parallel to things like other parts of the 14th Amendment, which say that no state can deprive somebody of due process or the equal protection of the laws. Congress can enforce those rules, it can add more penalties to those rules, it can create more procedures for those rules, but they're also just rules by themselves, that even if Congress did nothing, would still tell states that they can't deprive people of due process or protection of the laws. Now, to say all this makes it sound too simple, because when I say Section 3 is self-executing, that doesn't mean that it's self-enforcing, right? Section 3 itself is not walking around anywhere, collaring people who are covered by it, applying to them a scarlet S3 to make clear that it knows who they are, right? The actual adjudication of a hard case will still require our legal system to go to work on it. So if somebody tries to hold office who's covered by Section 3, there will probably be a legal dispute about it. But what Section 3 does is it just slots into all of our existing legal procedures for adjudicating qualifications to office, which it turns out are many. So one obscure procedure is the writ of quo warranto, the classic way in which you tested the qualification of somebody to hold office. There have been quo warranto proceedings under Section 3 to say this person, committed and engaged in insurrection or rebellion, they can no longer hold office. And the court says, yes, that's a valid basis for removing them. There also, in many states, can be ballot access litigation. So many states have a rule. I don't think they have to have this rule, but they do have a rule that they don't want to put somebody on the ballot who's disqualified. So they don't want to risk the people wasting their vote on somebody who later can't hold office. If they have that rule, then Section 3 is one of the qualifications to which that rule applies. There are currently 3 major pending lawsuits about Section 3 and Donald Trump, all brought on this theory in Colorado, in the Minnesota Supreme Court's original jurisdiction, and in apparently the Michigan Court of Claims, which hears ballot access cases in Michigan for various reasons. So there are lawsuits that will hear these cases, but none of them, the states can hear these cases as a matter of their existing election law jurisdiction. It doesn't require some special legislation from Congress, and it doesn't require a federal criminal conviction of something. You don't have to be convicted of insurrection or rebellion for this provision to take effect. Indeed, after the Civil War, when the provision was applied to many Confederates, none of them had been convicted of anything. Section 3 was seen as an alternative to criminal conviction, in some sense as a lesser punishment. Instead of trying to criminalize the behavior of our political opponents, the vision of Section 3 was maybe we don't need to do that if we can say just have a disqualification from office that'll sort of give the Republic the safety it needs. Okay. Point 3. To the extent of any conflict with prior constitutional provisions, Section 3 supersedes them. Now, there are not that many conflicts with prior constitutional provisions. For the most part, what Section 3 does is work in harmony with the existing rules of qualifications and the existing procedures for adjudicating them. Congress decides on the eligibility of its own members. So if there's a Section 3 case about a member of Congress, Section 3 is applied by Congress. There's no conflict there. But after the Section 3 was enacted, some of its opponents did argue that Section 3 conflicted with rules like due process or the rule against bills of attainder, because Section 3 imposes a disqualification on people without requiring a criminal conviction. To the extent there is anything to that argument, to the extent there is a conflict between Section 3 and things like due process or bills of attainder, Section 3 won that fight. Those were arguments made by opponents of Section 3 about why they did not want to enact Section 3, and the enactment of Section 3 in the face of those objections preempted those objections. This is especially important for people who are Civil War nerds here, because there were a couple of Supreme Court cases about the scope of something called the Ironclad Oath, while Section 3, decided by the Supreme Court while Section 3 was being written out for ratification, where when Congress tried to, just by legislation, or when the state of Missouri tried to, just by legislation, impose a kind of similar rule and say nobody can be an attorney in federal court who has previously committed insurrection, the Supreme Court said that's a bill of attainder, that's unconstitutional. Same thing for the state of Missouri. So constitutionalizing this principle was important to make clear those kinds of objections don't apply. More controversially, maybe not that importantly, but more controversially, to the extent there is a conflict between Section 3 and something like the free speech principles of the First Amendment, Section 3 prevails. So to the extent that there is conduct that one might think of as engaging in insurrection, giving aid or comfort to the enemies, squarely covered by the text of the clause, that now we would think is covered by some principle coming from the First Amendment, again, Section 3 wins that conflict. Okay. Fourth point, what does it actually cover? Section 3 draws on a huge history of uses of the terms insurrection and rebellion, both in the context of the Civil War itself, by Lincoln, Congress, the Supreme Court during the prize cases, and in a series of prior adjudications, sort of liquidations, especially the use of military force under the Insurrection Act. I'm happy to go into those details. I won't try to tire anybody with them now. So to say that, in our view, the working definition of rebellion is something like an effort to overturn or displace lawful government authority by unlawful means. An insurrection is something less than that. An insurrection did not have to be an attempt to take over the government. An insurrection was concerted, forcible resistance to the authority of government to execute the laws in at least some significant respect. The prize cases talk about how some insurrections blossom into rebellion, but not all. What we now call the Whiskey Rebellion was known at the time of the Civil War as the Whiskey Insurrection, and was a group of people who did not want to pay taxes, but also did not want to run the government. They just were not going to pay the taxes and were willing to use force if necessary to make sure they didn't happen. That's maybe important for when I get to point 6. All right, point 5. Section 3 covers a long list of officers, most of which are pretty obvious from what's on the board. The one point that is not obvious, but is very important, is that it includes the president. The president is not listed as a senator or representative or an elector of president and vice president, but the senator is an officer of the United States who holds office under the United States. And so, ironically, the reason senator, representative, and elector have to be separately listed is because those were all non-executive branch positions that would not be covered by the term officer, had to be separately covered. And you can see this if you look at the Constitution's Oath Clause, which contains the same list of offices in the same order, and is generally thought to include people like the president, who have to take an oath to support the Constitution. This actually is one of the rare instances where this came up in crystal clear fashion during the legislative history of the Section 3. So when Section 3 was being debated in the Senate, Reverend Johnson said, well, wait a minute, this seems under-inclusive. Where's the president? Why would you cover the senators and representatives and electors and not the president? And then Senator Morrill said, actually the president is covered because he holds an office under the United States. And Senator Johnson, if the Congressional Globe is to be believed, said, oh, that may be right. I see that's right. But you can see how I was initially misled because it says senator, representative, elector, and not president. So you have somebody actually making the kind of intuitive mistakes that people want to make while reading the clause, accepting correction, which is not something that always happened in the pages of the Congressional Globe in the 1860s. And this is the moment at which they could have redrafted it had anybody thought the objection had any merit. But apparently they all think they can move along and agree that the commission covers the president. After Section 3 is adopted, people talk about it stopping Jefferson Davis and Robert E. Lee from becoming president, as it seems to say. That brings us to me to the last point. Putting those 5 things together, and putting together what we know from the public record, Section 3 probably disqualifies Donald Trump from holding the office of president, and therefore should be applied in Colorado and Minnesota and Michigan, assuming that's what state law looks to keep him from being on the ballot in those states. The events of January 6th, 2021 were an insurrection within the 19th century meaning of the term, not that dissimilar from the Whiskey Insurrection or Fry's Insurrection or Shays Rebellion or a series of other insurrections that led up to the time of the framing. Donald Trump's conduct before the January 6th insurrection, in his sort of famous speech at the Ellipse, combined with his conduct afterwards in failing to take care that the laws were faithfully executed for a considerable period of time, probably count as engaging in insurrection within the meaning of Section 3. They may also count as aid and comfort to the enemies of the United States, depending on what enemies means, we can also talk about, but they may also count as aid and comfort. But either way, Section 3 applies to Donald Trump's conduct and therefore disqualifies him from holding office as president. I think we're going to have some back and forth later, so I won't try to anticipate responses, but I will say in general, this combination of propositions usually meets with one of 3 skeptical reactions. Non-skeptical reactions are great, but one of 3 skeptical reactions. One is, this is wrong. One of those 6 points is just wrong about the meaning of the Constitution. Happy to engage with that. A different reaction is, this is right, but bad. Section 3 is requiring something very bad. That might be true. I'm not sure what to make of that, but that might be true. Or third, who can say? This is complicated. This is complicated, and that might be wrong, but it might not be wrong, and we're not sure.
I agree with some of points. I agree that the Section 3 still applies going forward. There are some who don't. I do. I am not sure about the application to the president. There are there's some very serious scholars and former attorney general who say otherwise. The Reverdy Johnson exchange is probably, to my mind, the most powerful piece of evidence and support. I'm not going to get into that because I'm not persuaded that that Will is wrong about that. But let me then talk about some other points that I think make it somewhat unlikely that former President Trump would be disqualified from office. And I, by the way, for those of you who don't know much about my politics, am not a Trump supporter, never voted for him. I'd be very happy to have him, shuffle off the political stage. But as I'm going to say at the end, I fear that legal efforts that are implausible and that will be branded as trickery will actually strengthen Mr. Trump rather than weaken Mr. Trump. And so I'm concerned about this argument, but more so because the argument isn't just going to apply to Mr. Trump. There are quite a few instances, we've seen some in the recent summers, that involve forcible resistance to the enforcement of a law, which I think was Will's definition of an insurrection. Many riots do that. Courthouses have been occupied in recent times, and there have been a number of elected officials who speak out in support of at least the objectives of some of these. And I worry that, putting Mr. Trump aside, that this is unleashing yet another pit of legalism that is going to afflict our politics going forward. So I think we need to be very careful. And rather than adopting a sweeping definition, I would say as a principle of interpretation, I would advocate a narrow definition, precisely because what we're talking about is preventing voters from being able to elect candidates of their choice. That is a profoundly anti-democratic measure. We see that done mostly in autocratic states. It has never been done in the United States. Now, I do not think there are people who are kept from running. My 10-year-old grandson cannot be elected president of the United States. And if Will is right, then maybe Mr. Trump as well. But let us not leap easily to that conclusion through broad, sweeping, undefined terms. So I bring to this a disposition that we ought to be careful. We ought to look where we're leaping because this could be a very dangerous thing. So now specific points. First of all, you will note, looking at the language of Section 3, that it does not prevent an insurrectionist from running for office. It prevents an insurrectionist from holding office, not for running from office. And thus Section 3 provides no constitutional argument that a person has to be kept from the ballot or can't run. And if a case gets to the U.S. Supreme Court on this, which I think is actually probably rather likely, it would not be surprising for the Supreme Court to say that the case is not ripe meaning that until somebody actually is elected and tries to hold office, Section 3 simply doesn't come into effect. And I don't know that that's what they will hold, but let me tell you this. The 9 people sitting on our United States Supreme Court do not want to decide this case on the merits because they will infuriate half of the population. So if they can duck this by saying it's not ripe, well, I think that's not an unlikely thing. Furthermore, most states do not have, as Will said, many states prevent people who are not qualified to hold office from being on the ballot. Do you happen to know the number?
The number's 9.
I thought 9, so 9 seems to be the number. That's not a large number of states. So it's not going to happen in most places, right? And even then, can you keep a secret? Because I don't want, nobody please talk to the Republican National Convention and pass on this point. But I would not be surprised. The Republican Convention can nominate whoever they want to for President of the United States. It doesn't matter whether he's been thrown off the ballot in the elections we're about to take place. And it wouldn't surprise me if the Republican Convention takes the position that any state that does not put legitimate candidates, which they will think Trump is a legitimate candidate, on the ballot, their votes will not count at the Republican National Convention. And they will be within their rights to do that. It used to be relatively common for the Rules Committee of the two parties to exclude delegations for one reason or another, often for civil rights violations in their state. So I don't see how this is going to work. And then suppose he is on the ballot. People do not run for president in the United States. Electors elect presidents, right? But we vote for electors. We do not vote for presidents. And if the electors are insurrectionists, they can't run. That's what it says, right? But I don't think it's going to be possible to keep an elector off the ballot on the grounds that we think he's going to vote for an insurrectionist for president. Maybe it'll happen. I doubt it. So that's a hold office. That's the first point. We're not talking about running for office. We're talking about holding office. Then the next point is this an insurrection? We don't really know. We don't really know. And maybe Will is right that it's going to be given this very broad definition of forcible resistance to the enforcement of the law, in which case we have insurrections going on dozens of times every year. I think that's highly unlikely as an interpretation of Section 3 of the 14th Amendment. We do not know, but what we do know is that Section 3 was patterned on an 1862 statute called the Second Confiscation Act. In his article, Will refers to the Second Confiscation Act as a proto-Section 3. And the Second Confiscation Act, in adjudicated cases, equated insurrection or rebellion with treason, which is and said that people actually have to be found to have engaged in the functional equivalent of treason. The legislative history of the Second Confiscation Act indicates that it was passed in order to provide a lesser penalty than death for treason, because people who were Confederates were committing treason, and they thought it was not a good idea to put them all to death. Let's just take away their property and disqualify them from office. So that's what it was. And so it's by no means obvious that insurrection is as broadly defined as Will indicates. And I believe that it is likely that a court will want to distinguish between rebellion or insurrection on the one hand and a mere riot on the other. Now, as to what happened on January 6th, I have no truck. They obviously were doing terrible things and breaking the law and all that, but were they committing an insurrection against the United States? Did they want to overturn the United States government? I think what they were doing was bringing illegal pressure on Congress to decide a question in a way that the way they thought it was rightly decided. Now, I don't think they were right about that, but that looks a lot more like an ordinary riot to me than it does like an insurrection. But again, I don't know. I can't tell you confidently that January 6th was not an insurrection. I feel more confident about the next point, which is that Donald Trump did not engage in it, even if it was an insurrection. And Will says that he did two things that amount to engaging in an insurrection. That he made that speech at the Ellipse. Now, I've listened to the speech. Mr. Trump is, for all of his flaws, is not an idiot, and he carefully couched his language in ways that made sure that he was not inciting violence. He said, march on the Capitol peacefully, he said. Now, obviously, he was being a hypocrite. I'm not saying that there were dog whistles everywhere you look. But was this engaging in an insurrection? Congress voted 4 times between the adoption of Section 3 and the amnesty that was passed in 1872. There were 4 people who were elected to the Congress and who were challenged as ineligible to hold the office because of Section 3. And each of them had voted for, made speeches in favor, and encouraged secession. These were John Rice, George Booker, Lewis Mackenzie, and I failed to make a note of the 4th name. Excuse me for that. But Congress, or each branch of Congress, is the judge of the qualifications of its members. This is how Section 3 was enforced with respect to people elected to the Senate and the House, is that each House would vote on their qualifications, then they would debate whether somebody was properly an insurrectionist. Somebody who received a writ of marque and reprisal from Jefferson Davis and took his ship out and attacked Union vessels was disqualified, right? But not somebody who merely supported, voted for, and encouraged secession. That seemed to be the line taken. Now, there's no doubt that the Civil War was an insurrection. The question is, did they engage in the insurrection? It didn't come up very often because most of the people we're talking about actually took up arms, fought in the Confederate Army. So did they engage? And Will didn't say it tonight, but in the paper, Will frequently uses the words, instead of using the word engages in, he uses the words given aid and comfort to. I think he may have become more careful when this has been pointed out. But note that these are 2 different offenses. Engaging in insurrection or rebellion, or giving aid and comfort to the enemies. Now, Will said he doesn't want to talk about who the enemies of the United States are. There's a very good reason he doesn't want to talk about that, because it is a well-established term meaning enemies in war. This goes back at least to a case in, I think it was 1801, Bass versus Tengi, which was during the quasi-war with France, in which the Supreme Court interpreted this term, and it applies during war. It was also quite clear that this was true in the interpretations of that Second Confiscation Act that I mentioned before. Well, it didn't matter back in the day, because the Civil War was a war. The Supreme Court so held in the prize cases, if you have any doubt about that. It was, legally speaking, a war. There were a few people in Congress who disputed that, or at least questioned that, but not after it was decided by the Supreme Court. So everybody who supported the insurrection, who engaged in the insurrection, was also giving aid and comfort to the enemies. But when the very text of the provision we're talking about distinguishes between engaging in one thing or giving aid and comfort to enemies during war, I think it is not a proper textual interpretation to interpret engaging in as if it means giving aid and comfort. I think that this tells us that engaging in is actually being limited to people who are engaging in it. Now, that might apply to some of the Proud Boys who were marauding and wearing funny-looking outfits and so forth, but not I think, to Mr. Trump. And then a further point about this: if this was an insurrection and if Donald Trump engaged in it, one would expect the Biden Justice Department to have maybe charged somebody with violating 18 U.S.C. 2383, which is the statute that makes it criminal to engage in rebellion or insurrection, and as one of the penalties, disqualification from office. So this is an actual criminal statute on the books that instantiates Section 3 of the 14th Amendment. Well, the Justice Department has brought criminal charges against, does anybody know how many, 180 or something participants? Quite a few participants in January 6th. Not a one of them was charged with insurrection. Now, I do not believe, and please don't understand me to mean that no one can be disqualified under Section 3 unless they've actually been charged and convicted. That isn't what I'm saying. What I am saying is that the Justice Department has a whole bunch of evidence. They know everything about this. They've thought it through, and they did not believe that any of these people committed, or they would have brought the charges, right? They had every incentive to charge people with insurrection if they thought that the claim would stick. So I think it highly improbable, in the face of the Justice Department's evident conclusion that they did not commit insurrection, to conclude that that's what it is. So those are my actual legal points. But I would like to end with, Mr. Trump is a little bit like the Greek, the Greek myth of the Hydra. This is one of the Hercules. Every time you cut off its head, it grows 9 more heads. Well, Trump is like that. When his people, there are people who will support him no matter what, right? And then there are Republicans who are, they might be, they're not quite sure. Maybe they'll support somebody else. I think there's not, it's not so certain, right? But what happens every time people do this sort of thing is that they shift into his camp because they do not like it when people play legal tricks to deprive them of the ability of voting for the person that they think should be president of the United States. They think it is illegitimate, and it causes them to rally around Donald Trump. So let me just say, I wish this article Not only do I think it's wrong, but I wish it had not been written.
Well, good evening, and thank you for having me. I'm incredibly flattered and excited to be here. I started teaching in 1991, and about the next day started reading Michael's articles, really from the 1970s and 80s, about the need for judicial humility and judicial modesty. And I've told Michael this before, but I want to say it to the world. That work in my second, third, and fourth year of teaching law school absolutely changed the arc of my career. I thought you were right about every single syllable you ever said about humility and modesty. Originalism, not so much, but the humility and modesty point, I'm
proud to be that modest.
And as to Will, so I wrote a book in 2018 called Originalism is Faith. And I wrote it mostly because of Will and his usual writing partner, Steve Sachs. And every time and since that time, Will writes something every month, and I have to respond to it every month. I think I've written 3 law review articles, 1 with Judge Posner, 3 law review articles, 1 book chapter, and 113 blog posts responding to Will. And then, in preparing for this conference, I decided to listen to some of the recent recent podcasts that Will has been on, and I have 2 teenage daughters. I'm about to tell you, really shook me. I was listening to one of those. Will knows what's coming, and he's about to be embarrassed. I was listening to one of the many podcasts he's done, and the host said to Will, "You are the Taylor Swift of law professors." And I don't know you very well, but I sensed at the time you were not sure how to react to that. I'm guessing you still don't know how to react to that. I didn't know how I was going to react to it until 1 minute before I walked into this room. It occurs to me that anyone, and Michael Paulsen and I go way back as well, and I would have predicted that if there were any 2 academics who could have done this, it would have been Will and Michael Paulsen. They wrote a 126-page law review article on the text and history of the 14th Amendment, and it became a national phenomenon. All the media, everywhere, all you read for 3 days, a law review article. And I thought, well, that's Taylor Swift-like, so fine. Okay. As Michael said, I am an anti-originalist. I'm a non-originalist. I don't think history is irrelevant. Those aren't the same things, but I am an anti-originalist. And I have about 2 minutes to tell you why, because I was really brought here to talk about the pragmatic. A lot of the points Michael made, and I can't make them a whole lot better. I have a couple spins. But here's why I'm not an originalist, and neither should you. There are no originalists, sorry. There's never been an originalist justice in America, because as Arthur Macon, a person who wrote the first article ever to use the word living constitution, wrote in 1900, he said, what do we do when times change, but the Constitution stays the same? Which is an amazing thing to write in 1900. And what he said was, he defended a kind of originalism, which is more like our new originalism. But as he was doing that in a 2-part article in 1900, long before the legal realism movement, Holmes was around, but long before the legal realist movement, he also admitted this was all academic, because in the real world, the consequences will always trump the history. That's what he said. He was right. It has, and it does. So, for example, I think the very definition of insurrection, this is why I'm not an originalist, it is very possible that in 1869 it meant violent this, violent that. In 2024, what do we do with a computer virus that takes out our military? And that's obvious. It seems to me that's the same thing as attacking our military. Is that an insurrection? I assume so. Do I know? No, I do not. The dictionary today, the second word comes up is mutiny. I don't even know can President Trump, while he's in office, be engaged in a mutiny? Maybe, but I'm not sure how. In any event, the internet applies to free speech. Everyone in this room knows the internet applies. Free speech applies to the internet. The First Amendment applies to the internet. Randy Barnett likes to say that is some kind of gotcha statement. Okay, of course it does, but we don't know how. There are 100 unanswered issues about the internet, due process, freedom of speech, and nothing in 1791 and nothing in 1868 is going to help us with that problem, just like President Obama assassinated an American citizen having lunch in Yemen who was clearly a terrorist, but no court had ever said so. He wasn't on the battlefield. He killed him with a drone, and we're going to go back to 1791 to figure out if the President of the United States is allowed to do that or not to an American citizen. No, we're not. because that would be a useless enterprise. So I could go on, but I am not an originalist. So given that, I am someone who has detested Donald Trump since 1989. I am from New York originally. All of my friends detested Donald Trump in 1989. He proved himself a racist, so I don't want to take any, this is really important for when it gets posted, don't misinterpret my comments in any way as I would like Donald Trump to be gone out of our lives forever. I thought that in 1989. I think it more now. There are so many practical problems, but here's the big issue. This is the big problem. It doesn't take a legal mind to understand this. Both Michael and Will referred to him as Trump, 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 Trump. But where I come from in Atlanta, which is not far from Alabama, where I've spent a lot of times, they still refer to him as the president. They do. And that's not an insignificant point. And I need to say this. Although I was raised in New York, I spent most of my life in the South. If you don't understand Alabama, North Dakota, and rural Michigan, don't think you understand America, because you don't. I've lived in both worlds, and there is no question in my mind that Michael understated the case for the displeasure, anger, and likely violence that would occur if this man is not allowed to run for president again. And there's nothing in text or history or constitutional interpretation or anything 3 fancy or 2 fancy and 1/2 fancy law professors can say to change that fact. So that really worries me. The violence really, really, really worries me. We have no idea how this is going to play out. If a Secretary of State somewhere disqualifies Donald Trump, when it gets to federal court, what's the standard of review of the factual findings made by that agency? Obviously, legal issues would be de novo, but no one knows. No one knows that question, and I think it's a very, very, very difficult question. Michael's point is valid. This does not preclude people from holding office. It precludes people from running for office. I think Michael's exactly right that the Supreme Court would get rid of the case that way, because they didn't want to decide this. Sorry? What did I say? Okay, sorry. Okay. You know what I meant. See? The word president is not in here. They could have used the word president. Okay, I won't get into that. So what we're talking about here is disqualifying the front runner of the Republican Party by, I think, historical margins, except for maybe Reagan in the 80s. But, I mean, he is a front runner by historical margins. He is. Can't even say those words out loud without shaking, but he is the front runner. And he's the former president of the United States, whether we like it or not. To disqualify that person from being able to run for president requires a degree of certainty that we are not even close to having on all the legal issues that Will and Michael have carefully and with, I think, great skill put in front of us. The problem is that Seth Tillman, another law professor, along with Josh Blackman, and maybe more importantly, Kurt Lash, another law professor, have also written their opuses all in the last 3 weeks, disagreeing with almost everything they say. Now, I will admit here for the world that I happen to like Will more than I like those people. But I don't, look, I'm not an historian, and the truth is, there's only one, there's an historian sitting right there, but there aren't that many historians.
One in the room.
Okay, sorry. Yes, there's one over there. Yes, of course. Stack's right over there. But the reality is, this is another reason this all comes together. We don't want law professors doing history. Lord knows we don't. And here's why. And this is a point that actually the anti- or non-originalist literature has not focused on enough. Here is why. Will has amazing skills of persuasion. He just does. So does Mike. Many law professors do. You take those persuasive skills and you apply advocacy skills, and you apply them to history. Well, you can make almost any argument you want. You just can. And then, and even if you're making a silly argument, the odds that the Supreme Court recognizes it are very, very small. I don't think that taking him off the ballot works in any practical way, even if we were sure. But the major point is we're not sure. And I'll tell you this, the first time a Court of Appeals or Supreme Court has this issue, there are going to be amicus briefs about the history of this issue and about the text from 50 different people. do you really want judges to make decisions based on those disputed historical and textual assertions? I certainly do not on an issue this big. So again, where I come from, I know it's not true here, but and that's not true in Atlanta, but just about 5 miles outside of Atlanta, there are people who think they were cheated last time. In fact, there are probably about 40 million Americans, maybe more, who think they were cheated last time. In fact, 70% of Republicans think they were cheated last time. 40% of the American people think the election was a cheat. This is going to feel like a cheat 10 times that size. And those allegations we know to be false. This one, I'm not sure about. I agree, as a constitutional law professor, that this provision applies beyond the Civil War. I agree with that. On some podcast, you said that argument is so easy we shouldn't even stop on it. And I agree with that. But that doesn't mean we lose sight of what this is doing. It's disqualifying for the first, what it might do, disqualify for the first time in American history a frontrunner and former president of the United States in an already divided and polarized country. If this were clear, if this were like the president is 35, or one senator from every state, things I would, that's fine. That's not what this is. And the biggest proof of that is insurrection, the word insurrection. Insurrection is not like 35. Insurrection is not like 2 senators from every state. I am a European law professor when it comes to free speech. I believe America's premium on free speech is out of whack. I think it ignores other values. And for about 15 years in a row, I've gone to a conference where I'm the only American law professor who makes those statements. So when I say the following, take that into account. I've listened to and reheard and reread his speech, Trump's speech. I have no doubt, I have zero doubt, that if a Democrat had given, almost anyone in the world, had given that speech, no one would have thought it was incitement under the Brandenburg test. I don't like the Brandenburg test. I would reverse it. That's not here or there. It's political speech. He said the election was stolen, we have a fake government, and we're mad about it. We're really going to punish him for political speech? That's a bridge too far for me, and very few things are a bridge too far for me when it comes to free speech. And then finally, I think the biggest issue, really, I mean, let me be clear. There are about 9 legal issues that have to be resolved, and because of the way our country works, Will do his work, and Josh Backman will apply, and Kurt Lash would come in, and Mark Graber, who's my friend, would come in and say they're all right or wrong, and all of that. None of that matters. For those who don't know who Judge Posner is, he's probably the most important judge, certainly of our lifetime, not on the Supreme Court. And he was a pragmatist. And he's unfortunately very sick and can't weigh in on any of these things. But I talked to him once a week for 4 years. And I know what he would say. And he'd be right. I know exactly what he would say, and he'd be exactly right. We're going to debate whether to disqualify the former president and the front runner of the Republican Party and a person 70 million Americans voted for because of legalisms. That was Michael's word. I was surprised to hear it. But because of legalisms? No. Those aren't the right questions. The right questions are all the ones Michael talked about at the end and at the beginning, and the ones I've talked to you. So finally, as a matter of political strategy, because at the end of the day, law is politics all the way down, as Mark Tushnet once said. If Trump is the leader of a cult, this is Mark Graber's point. I can't improve upon it, so I'm just going to give Mark credit for it. If Trump is the head of a cult, then cutting him off, disqualifying him, ridding us of him would probably work. But if he is simply the head of a social movement, it would be a disaster. When you remove the head of a social movement against the will of the people in that movement, that gets to be very ugly very, very, very quickly. I do not believe Donald Trump and the 70 million Americans, I can't even say that sentence, and the 70 million Americans who voted for him, I don't think it's a cult. I don't think it's a social movement. I think it's something in between, or maybe both. A little bit of both, has characteristics of each. But I think I have enough experience in the parts of this country that are not Palo Alto, which is a wonderful, lovely place. But when you go to Alabama and Nebraska and Montana and Arkansas, I think it is more of a social movement than a cult. And I think that because, they don't like, you think they like this guy? I mean, I cannot tell you how many non-lawyers I've talked to who said, well, we're voting for Trump because we hate Hillary, or we're voting for Trump because we want change. We know he's terrible and awful and a liar and uses bad language. So I think that's the key question. But I think it's more a social movement than a cult. And if I'm right about that, it is not only politically impractical and politically dangerous and maybe even suicidal to disqualify him, it's the wrong decision. Because if 70 million Americans want him in office, I have a serious issue with, I think they're all crazy, but I'm sorry if anyone here feels that way, but I'm guessing there isn't anybody here who feels that way. But I think that is the key question going forward. Are we trying to stop Trump, or are we trying to stop Trumpism? I'm trying to stop Trumpism. That's really important to this country, and I think the way to do that is to beat him at the polls, and if we can't beat him at the polls, then what Jeffrey Toobin, who I have no love for, said in his famous book, The Nine, we get the Supreme Court we deserve. We may just, if we can't stop him from running for office legally and winning in 2024, then we probably deserve him. But disqualifying him will make the chances of him winning. The attempt to disqualify him and the failure of that attempt, it will fail. The Supreme Court won't let this happen. They won't. That's going to make Trump stronger. And that really worries me, and that's why I think we should, I'm really happy to be here, so I'm glad Will wrote the article. But that's not the only reason I'm glad. I think it would have been better to ignore this issue altogether. Thank you very much.
So Will is going to speak briefly, and then we're going to turn to you. I was right about one thing. We did not exercise self-restraint.
See the unrestrained.
You say we?
One small point on enemies, just so nobody thinks I'm running away from it. The funny thing about enemies, if you look at the text above, is it says enemies thereof. And there's a quite interesting question whether it's referring to enemies of the United States or enemies of the Constitution of the United States. And those might mean different things. I'm not sure what the answer to any of that, but I'll flag that. I just have two thoughts about the bigger picture issues that I want to throw out there before we have questions. So one is on the running, holding office thing. I completely agree that we don't have to enforce Section 3 at the ballot box, and that under Cousins versus Baude, the Republican National Convention has a First Amendment right to put whoever they want as their candidate. But the alternative to enforcing Section 3 at the ballot box is either enforcing it in January, either on January 6th when Congress counts the electoral votes, or on January 20th when they stand around and try to figure out who to administer the oath of office to. And if this is a recipe for a constitutional crisis now, boy, the January solution seems a lot worse, or not enforcing it at all, which might be the other democratic question. So it may well be right that this is just like chopping heads off the Hydra and making it grow more heads or whatever. It may well be right that this article is bad for the country. I wondered about that. That may be true. But I will say this is the thing that I keep worrying about. So in my adult life, which has not been that long, but in my adult life, there have been two presidential elections where the voters did not prevail. Two presidential elections where a majority of people voted for somebody and they did not become president. In 2000, George W. Bush. In 2016, Donald Trump. And I have a lot of liberal friends and family members who, felt intuitively that was unjust, undemocratic. And I could sternly lecture them about the rule of law. That the Electoral College requires this result, that the Constitution, you may not like the Constitution, but the constitutional system, and sometimes in our constitutional system, the majority doesn't win, and we have the constitutional system for good reasons, but it's the system, everybody plays by it, and so you just have to accept that sometimes in our imperfect system, we have to follow the Constitution and not the majority will of the voters. If in 2020, if in the next election, 2024, we don't enforce Section 3 as a valid part of the Constitution because we're worried about the will of a majority of the voters instead, I'm not sure what I would be able to say to that.
There's the microphone.
Hi, I prefer not to use my full name because it's going to be taped. So I'm Ethan. I'm a proud Trump supporter. I voted for him in 2016, 2020. I will vote for him even if it isn't handwriting in 2024. I am a naturalized citizen. I was born in a dictatorship. So my question for all three, and I agree a lot with Michael's perspective, and I don't think his name is
Eric.
Eric. I was born in a dictatorship. I have studied a lot how democracies become dictatorships. The United States is modeled after the Roman Republic, not the Roman Empire. There is always an element of deep state, you want to call it the way you want to call it, that say, I and only I am the guardian of the Republic. I'm going to protect the Republic against this dictator, and they're the ones who become the dictators. So my question is, I think that Michael and Eric understand very well that those of you making the argument, William, are playing with fire, because let the voters in the United States is with the people. It's at the beginning of the Constitution that make the decisions. We don't want to become like Spain or any other failed European country. Let the voters decide in 2024, because I do believe that we're cheated in 2020. I do believe so.
Can I ask you a question? Donald Trump has made it yesterday. Donald Trump told his supporters not to vote for him. Stay home and watch it on TV. Wait, let me finish. Hold on. He has made it very clear what he plans to do. And what he plans, it's not, America is a more complicated country than Hungary and other places, but what he plans to do is pretty much rule as a dictator. So I'm confused why you're not concerned about that.
At all. Let me tell you why. First of all, I do not support any insurrection whatsoever or turning the United States government. Not at all. So if I am on record, okay, I firmly believe in the democracy. Second of all, what some of you don't understand is when we vote for Donald Trump, I was disenfranchised. In California, we have North Korea's government since 2010. I became naturalized citizen in 2009. I took the 2010 election very seriously. I reached the conclusion that it was useless to vote because there are all these lobbies. I didn't vote in 2012. I wasn't going to vote in 2016 either because, okay, Bush, Clinton, I already have the Bourbons in Spain, and I gave up the Spanish citizenship. I was not interested. So when I watched that first Republican debate in 2015, I said, that's the guy. Because I'm not voting for a pastor, I'm not voting for my dear, fiancé who is there, I'm voting for someone, and if you look at the war in Ukraine, that would not have happened if Trump was president. You see what's going on in Israel? That would not have happened. So there are consequences of having people who are not qualified, not in a legal sense, but who are not competent to become presidents. Right? So I'm voting for the president of the United States. I'm not voting for my girlfriend, my boyfriend. I'm not gay, by the way. I'm voting for the candidate.
So thank you. And, it's always good for us to think about transitions. Our republic is not guaranteed, and the questions you pose are excellent. But let's not make this a night when we debate the pros and cons of Donald Trump. We could do that some other time.
The idea of letting the voters decide is very heartwarming, but last time I checked in the Electoral College and the winner-take-all system pretty much knocked the stuffing out of that idea. Would it not make sense for the various secretaries of state around the country to say, it's not for us to decide whether he engaged in insurrection or not. The text does not say how you answer that question. The only thing it does say is, to this layman, is in the last sentence, Congress can take it away and all of this would become moot. Why can't the secretaries of state just say, he gets on the ballot only if Congress resolves it?
So one of the questions is, why is this not a decision for Congress to decide whether to let President Trump be on the ballot? And I didn't mention it, but I do think that is one of the stronger arguments for why to think of it as self-executing. It's clear what Congress's role is the role in forgiveness. I don't think that. I think that would make a lot of sense. It would take a bipartisan majority of Congress, both the House and Senate, not very bipartisan, but somewhat, to decide that it was healthier for democracy to let Donald Trump on the ballot. Now, they might have some expectations before that happened. So former Confederates were expected to at least kind of apologize before they were granted amnesty. And I don't know if that's a deal that the former president would be willing to accept. But that would be a reasonable deal to propose.
I don't think Alexander Stephens, the vice president of the Confederacy, did in fact apologize, and he assumed a position in the House of Representatives as the leader of the Democratic Party as a result of the amnesty.
If I may, my intuition is Donald Trump would not want Congress to vote by 2/3 to remove this disability, pursuant to your statement earlier. You have to, and it's not about Donald Trump, it's our system. He wants publicity, he wants attention, good, bad, drama, kind of like one of my teenagers. He just wants publicity, and that would give him more publicity, and he'd be happy. And I don't think it would affect him or his supporters pretty much in any way.
Mr. Wofford.
Hi, Professor. I'll see you in office hours tomorrow. Thank you to Professor McConnell for organizing this event. I'll make this as quick as I can. The question is for Professor Baude. So this is actually the second law review article you've written that has made the cover of the New York Times and shaken up the nation. You came out quite strongly against qualified immunity on originalist grounds. You yourself have come out strongly against qualified immunity for police. Literally 2 hours ago, our very liberal law professor in civil rights litigation showed a video of you to our class. And so it seems to me that in addition to being the Taylor Swift of law professors, you're well on your rise, earned or unearned, as the left's favorite conservative law professor in America, as many people here know that you clerked for Chief Justice Roberts. And so my first question is, how do you feel about that?
I want to know that too.
And my second question is, can you tell us more about Will Baude before he became a professor? You mentioned you have liberal family members. What was your childhood like? What were the theorists and philosophers that influenced you? How did you basically come to have the worldview and legal philosophy that you have? That's brought liberal law professors to debate against you at Stanford Law School. It's very interesting.
Where did you go wrong?
I preferred the earlier work of Taylor Swift, but I gather she has a new song called Anti-Hero. I'm starting to feel... it's funny how people don't get nearly as excited about my articles about why the Supreme Court's decision in Bruin is correct, or why Lochner might be right under the original meaning of the Privileges and Immunities Clause.
You had to do this, didn't you?
Somehow those don't go as viral. I'm not quite sure what I'm doing wrong. If that was a real question, I guess I'll say, when I first started thinking about law, I guess as many people are, I started as kind of a legal realist. I was like, oh, I have strong political views, and presumably law is supposed to be a way for my political views to somehow prevail. Now, my political views are sufficiently libertarian that I then realized they were not going to prevail that often, so this might be a loser's game. But then I also took some classes on constitutional law and just started trying to think in the kind of from behind the veil of ignorance, the question of if before the constitutional case came up, you didn't know whether it was going to be, your candidate charged with insurrection or the other person's candidate, or you didn't know whose speech was at issue, how would you want to think about the Constitution? And I think there's a strong case to be made for thinking about the Constitution as a set of neutral rules that judges try to apply according to some kind of neutral principles. Folly and delusion, though some people think that may be. And that's sort of pushed me for a long time. I did have the great fortune to be miseducated for a year by Michael McConnell when he was sitting on a federal bench, and then again when I was a fellow here. But
I would like to make a comment about this, about Will. From my perspective as a progressive, leftist, communist, socialist, whatever, I read all of Will's work, which is hard, and his partner, Steve Sachs, and Will and I disagree on about 1,000 things. But the thing about Will that does distinguish him, in my opinion, from a lot of other originalists is that you just have to read 2 pages of any article Will's ever written. He's trying to get it right. I don't think he's succeeded, but he has. But he is, I'm being serious about this. I believed Will when he said in 10 podcasts that he didn't know how he was going to come out on this until he actually did the research. That's a really important point I want to emphasize, that I think Will and Steve both, his usual writing partner, and I think Michael also. Show me first, and then I'll give you my answer. Unfortunately, in our constitutional world today, we go to our corners and throw ad hominems at each other, and it's a bad thing. I think that's one of Will's special talents, and that's why I read him almost every day of my life to my great regret. Okay.
My name is Mark. I'm curious to hear your opinions on how impeachment factors into your arguments about Section 3. Obviously, Donald Trump was impeached by the House of Representatives on incitement of insurrection in 2021. The Senate acquitted him, although many senators voted to convict him. How does this factor into either the congressional vote, the last sentence of that, or just generally the notion that this has already been somewhat litigated?
I do think that was the proper way to deal with this, and I think the Senate I think they dialed it in. I think that what we should have had was an actual serious consideration of those charges, and in which evidence was actually brought and so forth. Most of the people who voted to acquit President Trump, well, actually he wasn't president any longer, but Mr. Trump did so on the ground that that impeachment doesn't apply to someone after they have left office. I've actually written an article in which I am quite persuaded that was incorrect, and I think they should have taken it more seriously, and the Constitution is quite clear that if someone is convicted on an impeachment, that the Senate has the authority to disqualify them from future office. Now, I don't think that the fact that he was acquitted is like res judicata and protects him from any kind of disqualification in the future. But I do wish they had done it the right way.
Yeah, I completely agree with that. That would have been the healthiest, clearest way to do this, the one that would have been the most likely not to raise some of the questions we have now about what will happen to every case, what is the definition of insurrection. Congress could have, tried to set a precedent clearly on what it thought made it incitement of insurrection. That would have been healthy for the Republic, and therefore...
And that's Exhibit C for what Michael and I were saying. The fact they didn't do that has everything to do with the fact that 70 million Americans still support this man.
Thank you.
So Mr. Barker and then Professor Gienap, or maybe in the opposite order.
First in time, first in right.
Professor Gienap.
All right. Thank you for the panel, as always. So one of your articles that maybe went viral, maybe didn't, maybe in a more restricted academic space is the one on constitutional liquidation. Many of my students scattered around this room read 2 weeks ago, a portion of. Why is Section 3, given its inherent uncertainties, if we're to trust Michael and Eric and other law professors who have weighed in, why is it not a candidate for Madisonian liquidation understood in your terms as something that doesn't have an operative meaning per se, but is to be worked out